Well, let me get us started. I want to welcome everyone who's signed in and continuing to sign in. I'm Kelly Testy, and I serve as the CEO of the Association of American Law Schools. Many of you are very familiar with us, but for those of you who may not be, AALS, as we're known, is the Learned Society for Law Faculty in the United States, and it's also the membership organization for those law schools who share with us the mission of advancing excellence in legal education. And we're really pleased to bring to you today this teach-in webinar series on professional independence in the legal profession. This is a six-part series, and so this is the start of it today. In addition to today's topics, we will also be covering many others, including executive orders and the federal investigation of law firms, professional independence and baseline principles, judicial independence and the rule of law, separation of powers, and also offering some global and comparative perspectives on these important issues that are so much at the forefront of our legal and policy discussions today. I want to give a special thanks today to those speakers who are here with us. And in just a moment, I'll introduce Austin Parrish, the Dean at UC Irvine, who is going to also offer some words of welcome as we get started. Dean Parrish served as the president of AALS last year and had a marvelous term for us. So I thank him for all he's done. As I turn it over to Dean Parrish today, I also want to let those of you know who may not be familiar with our other programs that I hope you'll visit aals.org because we offer so many different kinds of webinars and programs on legal education. Just by way of example, coming up in just the next stretch of a couple months, we have a webinar on scholarly work in legal education by the Journal of Legal Education. We've entered a wonderful partnership with West Academic on artificial intelligence. And we've offered already one webinar that's recorded on our website that's about tools for students. And we'll soon be offering a second webinar on the 15th of April on tools for faculty. We also, as many of you know, convene big meetings of law faculty and staff across the country. And our clinical legal conference comes up in Portland in early May, our new law teachers conference in early June in DC, and of course, the wonderful annual meeting that's the largest gathering of law faculty in the world that takes place every January, this coming January in New York City, as Danielle Conway, the Dean of Penn State Dickinson Law, begins her presidential term. So with that, I want to give thanks again to our panelists today and a huge shout out to Austin Parrish for all his energy in advancing the important dialogues that we need to be engaged in today as we continue to work to keep legal education and the legal profession strong in our nation. Austin?
Thanks so much, Kelly, and great to be here. Thanks for those of you who've joined us here. Really a big thanks to today's presenters for helping us spur this webinar series. We've really had a group of wonderful centers and programs from law schools around the country. So tonight we begin with the panel on rule of law, executive orders in the legal profession. Next week, we'll have panels hosted by Princeton University's Law and Public Policy program on the principles of legal independence. Then will be the University of Washington School of Law with a panel focused on the judiciary. We'll then have Georgetown Center on Ethics and the Legal Profession focused on separation of powers. Indiana University Bloomington Stewart Center on the Global Legal Profession will have a panel on global issues, including discussing foreign anti-bribery enforcement. And we'll end the series with Harvard Law's Center on the Legal Profession, which will have a panel on professional independence and the future, given the volatility, uncertainty, complexity, and ambiguity that exists today. I just have two quick announcements before we begin. One, students are able to obtain a certificate of completion if they participate in at least 5 of 6 of these webinar series, 5 of 6 of the webinars from the 6-part series. And you can get more information on that from the ALS website focused on this series. And second, we're really grateful that We have a student writing competition. Peter Zuchhauser, who's on the call today, will be the chair of the committee that will be selecting the papers. There's a $3,000 cash prize for the best student paper. The details, again, are on the AALS website. The Journal of Legal Education has agreed to review the student papers that are selected for publication consideration. So if you're a student, I hope you'll consider looking and checking out the student writing competition. So with those announcements, tonight we have an all-star panel who I'm going to briefly introduce. The ALS webpage for the webinar series has links to their bios, and I encourage you to read them because I'm going to do this very quickly. So moderating the panel is Professor Ann Southworth, the Pryke Chair and a Professor of Law at the University of California, Irvine, and is the co-director of the Center for Empirical Research on the Legal Profession. We then have three experts who are deeply involved with litigation and the executive orders around law firms and universities. First, we're joined by Highland Chen, who is a partner with Munger, Tolles, and Olson, and was a co-managing partner of the firm from 2019 to 2025. Together with her partner, former U.S. Solicitor General Don Verrilli, Highland organized the amicus brief effort of over 800 law firms, both at the trial and appellate level, involving lawsuits challenging Trump's executive orders against law firms. She currently represents Sussman Godfrey in their challenge to the executive order. Next is Matt Jenkins, who is a partner at Hecker Fink and a founding member of the firm's Los Angeles office. He represents and advises university and law firms in matters arising from orders made this past year. He previously served as the chief of the criminal division of the United States Attorney's Office for the Central District of California and served as a federal prosecutor for almost 17 years. And rounding out the panel, we have Peter Zuchhauser, who is one of the nation's leading consultants to the world's largest law firms. He heads the Zuchhauser Group, which advises many Global 50 chairs and managing partners, including on issues related to the law firm executive orders. So with that brief introduction, let me turn it over to Ann Southworth, and to the audience again, thank you for joining us.
Terrific. Thank you very much, Austin. Peter, can you set the stage for us? So we know that in early 2025, the Trump administration launched a series of actions against law firms. What were the executive orders, the presidential memoranda, and investigations? Which law firms were targeted and how?
I'd be happy to, Ann. Before I say that, I want to thank you for moderating. I want to thank Austin for all the energy he put into this, and AALS and Kelly for everything they've done. It's a great series, and I'm honored to be part of it. So, as you said, about a year ago, February 25th, last year, the government began an attack, a widespread attack on law firms with a series of executive orders, presidential memoranda, EEOC investigatory letters, and letters from the FTC to 40 some odd firms, indicating they may be investigated for any trust violations related to their diversity hiring practices. All told, well over half of the AmLaw 100 firms were recipients of one or another of these. The executive orders and presidential memoranda raised serious constitutional issues, and an amazing number of them, considering how brief each one was. But they raised First Amendment rights issues, due process and Fifth Amendment rights, right to counsel and Sixth Amendment rights, and separation of powers provided for under Article 1 and Article 3. So they were quite far-ranging, and they were retributive in their nature. They actually were aimed at some individual people, not just the law firms. And that was a blessing in disguise, because it it provided better grounds for, or additional grounds for challenging them. So they were directed at 6 firms. Covington and Burling was the first for providing legal services, free legal services, to Jack Smith, who had served as special counsel indicting President Trump after his first term. And what the executive order ordered was to suspend security clearances for Covington lawyers, to terminate all of Covington's federal contracts, and to broadly speaking, end the weaponization of the federal government. Somewhat ironically, I might add. Perkins Coie received the second one on March 6th for its work on behalf of Hillary Clinton related to Russia's election influencing activities, its work with George Soros, and its DEI policies. again, suspending security clearances, terminating government contracts, and directing the federal government to refrain from hiring Perkins employees. Paul Weiss received its executive order on March 14th, and that was for Mark Pomerantz, a former Paul Weiss partner's work on the prosecution of Trump by the New York District Attorney's Office that resulted in Trump being convicted on 40 felony counts in the Stormy Daniels matter, and for bringing actions against the January 6th Capitol rioters. Fourth was Jenner and Block on March 25th, saying it undermined justice by engaging in obvious partisan representations to achieve political ends. The order detailed the hiring of Andrew Weissman after Weissman helped Mueller, the special counsel in the Trump-Russia investigation, which was the subject of the next executive order, against Wilmer Hale. That was on March 27th for Robert Mueller's work as special counsel in the Russia election interference investigation as punishment for its connections with Mueller, who worked there both before and after he served as a special prosecutor. And then last but not least, the case that Hylin is involved in as counsel against Sussman Goffrey for its representation of Dominion voting of Dominion voting machines, excuse me. Perkins, Jenner, and Wilmer sued and in short order won injunctive relief. Perkins' TRO was granted on March 12th. But the apple cart was upset on March 21st when, in a meeting in the Oval Office with President Trump, Paul Weiss, his managing partner, capitulated or settled the dispute that was raised by the executive order. In an odd occurrence, at the suggestion of Bob Jeffrey, Sullivan and Cromwell's chairman, who was representing Trump on other matters and was brought into the meeting by telephone call, Paul Weiss agreed to provide $45 million in pro bono work for causes Trump supports and to eliminate any unlawful DEI practices at the firm. Unfortunately, Paul Weiss's settlement triggered 8 other top big law firms who were not the subject of any EOs to enter into agreements with the government in fear of being in Trump's crosshairs. Those 8 firms were Skadden, Wilkie, Milbank, Kirkland, Latham, Simpson, A&O Sherman, and Cadwalader. Together, all told, they agreed to provide $1 billion in pro bono work for causes Trump supports. This has been the subject of much of the controversy around the executive orders, even though none of these firms received executive orders. Since then, 3 of the firms have indicated they are doing work for the Commerce Department. It has been reported in the legal trades that this work may be credited against their pro bono commitments. The District of Columbia Bar, which we'll talk about in a little bit, has indicated that the pro bono work these firms have agreed to provide gives rise to professional code of ethics, conflicts, and other issues.
So maybe we can bring Hylin in at this point to talk about the law firms that chose to bring actions challenging the executive orders. Can you describe those lawsuits and the current status of the lawsuits?
Sure. So as Peter mentioned, 4 of the law firms who received executive orders chose to sue. Each of them went to court and sought temporary restraining orders, which were granted. And then each skipped the preliminary injunction phase and went straight to a motion for summary judgment for a permanent injunction, and each was granted. Those lawsuits raised a number of claims, most significantly that these orders violated the First Amendment. And they did so in a number of ways. They punished the law firms for their protected expression of viewpoints which in some instances happen to be disfavored by the president. And they were retaliatory in violation of the First Amendment. They also violated the law firm's right to associate and to petition the government for redress. Effectively, they were being punished by things as significant as you are barred from entering a federal building. You are any federal contractor who does business with you, we need to know about, and we're going to reconsider that relationship. It also violated the due process clause. It violated the right to procedural due process. These executive orders were just issued out of the blue, and these orders were unconstitutionally vague. But the core argument is really a First Amendment violation. While one can perhaps theoretically quibble about, the way in which some of these individuals who are singled out engaged in their prosecutions or investigations, there's just no way in which that sort of work should allow the federal government to come down in this way. And just to give folks a flavor of what Sussman Godfrey was retaliated against for doing, the executive order singled out Sussman Godfrey for a few things. It represented Dominion voting in a successful lawsuit against Fox, which resulted in a hundreds of millions of dollars settlement. The executive order called out Sussman for donating money to an organization promoting gay and lesbian equality. And the executive order called out Sussman for promoting the idea that women and men should receive equal pay for equal work. Because of those things, which the president found objectionable, the government felt that it was okay to subject this law firm to just punishing and potentially crippling effects of this executive order. And where these cases are now, they're up on appeal in front of the DC Circuit. And so some of you may have seen the news about how the government initially said, you know what, we're going to withdraw our appeal. We're going to dismiss our appeal. Never mind. And then the very next day, after headlines appeared in the New York Times saying that, Trump has folded, DOJ then came and said, you know what, we've changed our mind. We're going to withdraw our dismissal and we're going to proceed. And so the government's brief has been filed. The 4 law firms are filing their briefs this Friday. An oral argument has been set for May 14th.
Hi, Lynn. You've also been involved in the amicus briefs filed on behalf of the firms that have challenged the executive orders. Can you describe those efforts?
So the amicus brief that was drafted by my partner, Don Verrilli, we believed, was nonpartisan, presented very basic tenets of constitutional law, basic principles of the First Amendment. And initially we thought, what law firm wouldn't sign on to this? These executive orders pose an existential threat to other law firms. They could be issued against any of us because they're being issued for seemingly no reason. And they clearly violate the law. As it turns out, it was a real challenge to get the major law firms to sign on. I think it's been widely reported in the media that very few of the so-called AmLaw 100 firms, meaning the sort of richest law firms in the country, very few of them signed on. But at the end of the day, it was hundreds of mid-size and small law firms and solo practitioners across the country who did sign on. And so while it was a disheartening exercise in some ways, that really illustrated the fear that these executive orders engendered, it also was really encouraging to see this outpouring of support from lawyers across the country.
Mac, some of the targeted law firms negotiated deals with the Trump administration and didn't sue. Other firms entered into preemptive deals to avoid being similarly targeted. Can you offer any insights into what accounts for the differences in the firms' responses? What were the arguments for and against settling or fighting? And what did the firms that settled with the administration agree to do? And I think Peter began to address the last of these points, but perhaps there's more to say.
Sure. Thanks, Anne. I think I'll offer some insights and really just some opinions, particularly as a former prosecutor. I was at DOJ for 17 years, where I prosecuted all types of cases, including public corruption cases. And why that's relevant here is because taking both sides of the argument in terms of why firms either capitulated or preemptively capitulated, there is some argument, or at least explanation, that one side of it is that they are essentially co-conspirators to the downfall of legal independence, that they're willingly engaged with the administration to basically buy their way out of trouble, save themselves, sacrificing the rule of law, etc., in order to be in Trump's good graces, which, again, we call them sort of co-conspirators in that downfall of legal independence and the rule of law. The other argument that I think has some, attraction to people is that, are they just more extortion victims from a tyrannical government, tyrannical executive, akin to someone who is bullying, extorting businesses where think a political official, where they're requiring bribes in order to do business in their district. And so then they say pay the bribe because there's an existential threat to their business. So they have to survive, they have to compete. So they say, we don't want to pay these bribes, but we will to survive. That is both in a criminal law context, makes them an extortion victim and a bribe co-conspirator. So I think there is some, again, grounds for reasonable disagreement of where these law firms find themselves. Without making it too much editorialization, I will note that Hecker Fink, my law firm, signed on to Hyland and Munger's amicus, challenging these clearly unconstitutional orders. That, again, every district court to resolve the issue has resolved it in favor of the law firms fighting it. I think there is certainly a place where the district courts are on the front lines of deciding the rule of law, defending the rule of law. And law firms particularly should be empowered to take those fights to the government. This isn't go back to my analogy, some sort of mom and pop shop that is in some district, in some corrupt district, and really needs to pay the bribe fee to survive. But again, they will say, particularly ones with big private equity clients who know that the government, we've seen this right now, will threaten all kind of financial levers and tools that it has to really make that threat existential to even the richest law firms. So other firms like my firm and some others, where we're only litigation, it's a litigation boutique. We don't have transactional clients. We don't have private equity clients. We didn't have that same existential threat. And I think, as I watched, as Hyland pointed out, the amount of firms on the amicus go from, like she said, everyone's going to sign it. Then, well, most everyone's going to sign it. Then some people are going to sign it. At some point, it's like, is anyone going to sign it? I mean, it really was ultimately a disheartening, but again, ultimately, I think empowering from the smaller firms who are really, again, on the front lines to defend the rule of law. And I think that has been really impressive to see. And the things that, to your second part of the question, what these firms have agreed to do, I think Peter touched on it too, is pro bono for Trump is sort of how it's been described. Very amorphous, very unclear. I think when most people think of pro bono, particularly people who have worked in a pro bono space, you're representing underprivileged individuals, low-income communities, people who can't afford legal services, people who can't navigate the legal system, giving them and their voice, a vote in the legal system. But I think it's been very unclear whether the Trump administration sees pro bono in the same way, or is pro bono, you work for free to do whatever I want, tariffs, sanctions, other things. So I think it's still yet to be seen what pro bono means is consistent or inconsistent with the agreements that Trump has extracted from these law firms.
I'd like to ask all the panelists to address the question of what ethical issues the targeting of law firms and the deals struck by law firms raise, and more generally, what are the broader implications for the rule of law? Maybe Mac, you can start.
Sure. I think the two biggest ones, I mean, we're talking to law professors and people in the legal world. I think people, even non-law people, know that a lawyer has an ultimate duty to its client, to his or her client, to zealously advocate on their behalf, whatever their interest is. That's literally like step one of their job. But for example, if someone hired a law firm in a case, in a criminal investigation, a federal criminal investigation, to defend them and defend their rights. And that law firm had previously entered into an agreement with the Trump administration saying that it would also work for the Trump administration, or that would sort of buy its way out of trouble. The concern from that client is going to be, can this person really zealously advocate against the entity that just extorted them? Will they tailor their arguments, make it more friendly? Will they be less aggressive? How can you ever sort of trust your law firm to do that fundamental tenet of legal advocacy and zealously advocate for you? And I think what's happened is a lot of clients have fled sort of some of those big firms because they don't have that trust anymore. And I think it's also, frankly, chilled some law firms from taking on certain clients because they don't want another executive order. They don't want DOJ inquiry. So it's really, I think, isolated some very needy, very important potential clients who are getting their legal options stripped from them. And then once they hire a law firm, whether that in itself, those firms can actually comply with their ethical obligations, I think is a very significant question. And I know the DC Ethics has some thoughts on it, but I think Hailen was going to talk about that or someone.
Yeah, sure. I can talk about that. So, the DC bar is actually the only bar now to have really put out a formal statement about the potential ethical issues raised by the settlements that the capitulating firms entered into. And they raised 3 ways in which the ethical rules may be violated. One is through conflicts of interest, which both Mac and Peter have touched on. Lawyers have an obligation to avoid conflicts. And if there is a conflict, to obtain waivers, which require your client to waive with informed consent, knowing of the extent of the waiver. And the DC Ethics opinion makes clear that because of the vagueness of these settlements, you can't give your client full knowledge of the contours of the conflict. You have agreed to, X million dollars of pro bono services for the government. You don't know what issues those will involve. You don't know what future things that may require you to take on what you were obligated to do under these settlement agreements. And so how can you advise a client about how to waive that conflict? It really poses significant real conflicts of interest issues. The second thing the DC Ethics opinion raised is the improper restriction on a lawyer's right to practice. And their ethical rules in many jurisdictions prohibit agreements that restrict a lawyer's right to practice. And that's what these agreements do. They say the lawyer has to take on this amount of pro bono work. Post capitulation, after there was a lot of bad media, a lot of these firms went to great lengths to say, we have total discretion over what we get to do and what we don't get to do. Seems kind of ephemeral, but the restriction on a lawyer's right to practice is the second ethical issue the DC bar opinion raised. And then the third one is really interference with professional independence. And the idea is, how can you really be independent in your zealous advocacy for a client, as Mac described, if you have this obligation, this sort of, indefinite obligation to represent the government pro bono in all manner of unspecified cases. And so it really poses a serious ethical dilemma for lawyers. And then the practical effect is one that Mac touched on, which is that these executive orders have already had a silencing and a chilling effect, especially at major law firms across the country. It has chilled them from their willingness to take on pro bono matters adverse to the administration. I've heard from some colleagues that it has chilled their ability to take on hard-hitting positions that the government may be unhappy with. And so it's already, even if you're at a firm that's not directly targeted by an executive order, even if you're not at a firm that has entered into one of these settlement agreements, lawyers are finding that they are being chilled in their ability to zealously advocate for their clients. And that is what is really pernicious. about these executive orders is the broad-ranging chilling effect it has had on the profession. If you talk to folks at pro bono organizations, they're saying it's harder than ever to find law firms to partner with to take on the important work that they do. And we all know that in this administration, there's more of that work to be done in making sure that people's civil rights are protected, in making sure that the benefits to which they're entitled to aren't taken away. And these executive orders, even though they have been overturned or, enjoined by 4 different courts, are still having that chilling effect.
Peter, did you want to add anything to this?
Yeah, I would add, you may recall during Trump's first term, he issued the Muslim ban. And there were Muslims at airports around the country who were trying to board flights and deplaning flights. And many of the firms, if not all the firms that received executive orders, sent their lawyers to the airport so that they could represent those Muslims who were being deprived of their rights. And the turnaround after the executive orders have been issued has been dramatic. The fall off that Hylin mentioned a moment ago in pro bono representation, in talking to law firms and pro bono organizations, is most noteworthy in their efforts in their pro bono efforts previously to represent immigrants who need counsel in connection with their right to stay in the country or not be deported. So it's been quite dramatic, that impact. I have read data that the fall off in representation by big law is as much as 30%. And in terms of the impact that Mac noted on pro bono organizations, and I think Hylin touched on it also, I spoke with the executive director of our local public law center in Orange County last week, and they've had to lay off 5 attorneys from their staff. It's not a big organization because of lack of resources and support from outside firms. So this is not just a hypothetical that's occurring. It's actually resulting in a tremendous diminution in access to justice by so many people. And access to justice is so critical to the ordinary citizens' respect for the rule of law. That's the building block, the essential building block. And if they don't have access to justice, our whole system starts to crumble.
Can I add on to that? One other thought too is that this affects the ability of our judiciary to do their best work. When lawyers can't operate independently, judges are deprived of the best arguments and the best challenges and the things that need to be in front of courts. We pride ourselves in having an independent judiciary in America. It's one of the hallmarks of our system of government, but it depends on an independent bar. And if we have no independent bar, you can't have an independent judiciary. Courts need to be able to hear the best arguments from the best lawyers. And if they are being chilled in their willingness or ability to take on cases and to make the best arguments, that hurts the foundations of democracy. And it's especially dangerous for our country now when we are about to approach the election. So Peter's example of law firms sending folks to airports to help with people affected by the Muslim ban. Back in prior elections, law firms were organizing on election protection efforts. People were getting lawsuits ready to protect free and fair elections. I don't know that I see the same effort right now as we are approaching midterms and as we are approaching the even larger general election. And we already see efforts underway to try to undermine the integrity of those elections. And so with law firms being chilled, that has an effect on our whole democracy.
And I would just mention one sentence here that Deborah Pearlstein mentioned in connection with this that shouldn't be lost on the audience. And that is, despite all the amazing work being done by the firms that are helping representing the firms that were subject to the executive orders, we're winning the battles We're winning in court, but we're losing the war. The war is that big law and other firms are afraid to challenge the government. The executive orders are having their intended effect, even though we're beating the government in court.
So, Hyland, I wondered if you could speak from your experience as co-managing partner of your law firm for many years. Can you describe how the stances taken by various law firms are impacting their practices? And what have been the effects on the climate of law firms and the climate of practice?
So it's been a sort of mixed bag, I would say. In the wake of all the capitulations, we did see some departures of prominent lawyers from certain law firms. And so, a group of lawyers quite publicly left Paul Weiss to open their own firm. These sorts of departures happened at a number of other firms. And that was, I think, sent an important message to the legal profession. However, many of those law firms have continued to thrive. People thought there would be some sort of a mass exodus of clients, and some clients did shift their business from capitulating firms to firms that did not, but not in massive numbers that affected firms' bottom lines. Not that we've seen. What we've seen in the American Lawyer report of 2025 earnings is that many of these firms are reporting their strongest financial years in history. And so we haven't seen a huge hit to many firms' ultimate bottom line. We are seeing some effect on recruiting. And so one interesting thing that happened in the wake of all of this, all of these shenanigans, was that law students started to organize, and there was posted on a Reddit spreadsheet of the firms that capitulated, sort of listing all the firms because law students were interested about knowing what firms were doing. It could affect their decision about where to go. And so at our own firm, we have seen an uptick in real interest in our firm because of the stance we've taken. We've heard from other firms that they're not standing up and signing the amicus brief, or their capitulating has affected their recruiting. All of this, of course, is happening at the same time that the whole law firm interviewing and hiring cycle has gotten earlier and earlier and earlier. And so it's hard to kind of tease out the effects. If people are seeing a decrease in recruiting, how much of it is attributable to that confounding factor as well. So I would say that's the financial impact. There's a recruiting impact, but there's also a morale impact. And I know Peter has thoughts on this because he's spoken to folks at a lot of law firms. Morale was pretty bad at some of these firms. A number of lawyers at the capitulating firms felt like they were not communicated with. They had the rug pulled out from under them. They heard about the settlement from, a friend or a family member who saw it on the news. And so it has sort of highlighted perhaps the weaknesses and the problems with how law firms govern themselves, and how people feel like they are actually a part of their firm.
Matt, did you want to add anything?
Just quickly, and I think I agree with everything Hyland just said, but I'll emphasize it. We have seen also the burgeoning blossoming of boutique litigation shops. Hyland mentioned a lot of the big firms lost some pretty prominent litigators, and that ties back to what I said, where if you go to a litigation shop, you don't have the same private equity concerns. You're not trying to pay partners $13 million a year to keep the best ones. And I think people who, went to law school to litigate to make a difference, it's really a moment, really a watershed moment. And so our firm, again, I'll talk about other firms, but we were the beneficiary of some of the big firm partners who departed for various reasons, but including that they wanted to go to a place that was continuing the fight, that were on the front lines. Our firm represents Brego Garcia, the person who's wrongfully deported to El Salvador prison. We have cases against ICE. So work's overflowing to litigation boutiques like us, which is great, but it is, again, disheartening because all these other litigation shops have great lawyers, great trial lawyers, great briefers, and should be involved. And so on the recruiting end, again, I've seen that spreadsheet too, that law school spreadsheet. And again, to me, I'm heartened by it because it wasn't just who capitulated. It was when. It was if they didn't capitulate, what did they do? Did they stay silent? Did they file an amicus? Did they speak out? Did they make a social media post? So the law students are digging deep. And the spreadsheet was very informative to me and our firm, but also on other firms too. So it's good intel. But the interview process itself, when we interview law students or interview lateral candidates, they're interviewing us. I've been asked several times, like, what was your position? What did you guys do when this happened? And, I think that's a big indicator right now as these fierce fights for the law school talent continues to, change the way OCI happens, but also changes sort of the merits of the interview where we're being interviewed in this watershed moment. Like, what did we do? What did we say? And prove it. And I like that. And I think lots of firms have good answers and other ones have more difficult answers.
There's a client side to this too, Anne, is what I would say. And I think many of the firms believed that if they didn't capitulate, they would be persona non grata at the government. And in trying to, let's say, get a big merger cleared at the FTC, they wouldn't be given as favorable treatment as the firms that capitulated. So there was a fear on the one hand about that. But I think there was also on the other side a feeling that if they did capitulate, they would ingratiate themselves to the government and they would get better treatment. And so the transactional lawyers, it wasn't just in antitrust, it was in all kinds of regulatory matters. The transactional lawyers really felt driven for their clients. They thought their clients would want them to capitulate and enter into a settlement agreement and be in good standing with the government. On the other hand, people don't hire trial lawyers to capitulate. They hire them to fight and to stand up for them, especially when the case seems so strong. And so this created a split within the law firms on how clients would perceive them. And that's been very challenging in terms of the morale at firms. It's never been a division like this before at firms, I don't think. And it's quite understandable, but it's also quite disappointing that the administration has managed to drive this wedge inside law firms. So it's a real morale issue. Just on the attrition issue, I read this week in Bloomberg that at one firm, Paul Weiss, their attrition among associates has been 70% higher this year than last year at the same time. Something like 250 associates have left Paul Weiss in the past 12 months, compared to about 120 or so, or 100 or so in prior years. So it's had a real effect. And that's also a morale issue. And it's vexing for associates who might be in their 6th year, 7th year, up for partner, and they've lost confidence in their firms. And the reasons they joined those firms were because the firms had such strong pro bono programs. So it's been a real hit for morale in law firms.
I'd like to invite each of you to offer a few general thoughts especially for the students who are on this webinar, but also for lawyers and other participants in the webinar. And then I'll also hope to get you to address a couple of questions that have come in through the chat. But to that general point, Hyland, do you want to get us started?
So I think it's important for law students to know that, once you become a lawyer, or when you become a lawyer, you're going to be taking an oath. And that oath requires you to swear that you will uphold the Constitution. What these executive orders are doing is blatantly unconstitutional. It's not even a close call. And I think it was incumbent on everyone in the profession to stand up against it, against what the president was trying to do. But only some people did. And so it's caused me, and I know others, I've had conversations with Peter and Mac about this, on what that oath means. And to really understand what it means to uphold the Constitution at a time when the very independence of our entire profession is under attack.
Mac?
Sure, I'll take that oath baton that Hyland just noted because it's important important to me. My dad was the chief probation officer for San Diego County. He was a public servant for 35 years, and he was the first Black chief for San Diego. But what I remember most from his farewell speech is he ended it with saying, "I worked at this job for 35 years, and every day I strove to keep my oath." And as I was a federal prosecutor, that meant more and more to me, because we also take an oath as a federal prosecutor. But what I'm realizing now is, yeah, I also took an oath just to be a lawyer, and that oath matters. And the fact that my dad was so proud that that was his crowning achievement, that he kept his oath for 35 years. And I was like, of course you did. Like, why wouldn't you? But now we're seeing why people don't. And it's sad and it's disheartening. But I agree wholeheartedly that it's even more important for law professors, but particularly for law students who I talk to regularly. And some people ask, well, why should we be in law school if the rule of law doesn't matter? And my answer is, it's sort of, I looked up the Dickens quote, that it's the best of times and worst of times. Here it's kind of the worst of times and best of times in the rule of law, meaning that it's really under threat like no other time that I've been a lawyer in the last 20 years. But that means you, as lawyers, as future lawyers, have the opportunity to do something about it. People say they want to go to law school to make a difference. Most don't. Most travel, do other great things, but not really make a difference. A law student right now, a burgeoning lawyer, you have a real opportunity to put your oath to the test, to put your commitment to making a difference to the test. And that's through being on the front lines of some of these battles for the rule of law. And so join us, please.
Peter?
Anne, I would mention that it was 3 unnamed associates who challenged the EEOC order letters, investigatory letters, and they won in court, and the administration conceded that the EEOC investigatory letters were advisory only. So if you think as an associate, you don't have power, you really do. And so what I would say is be prepared to take these causes on. Reflect on what you can and cannot do, what you would do when confronted with challenges like these. Don't get caught off guard. And I think many of us got caught off guard. We never imagined that the administration would issue these orders. And I think the firms that capitulated, that's part of the reason they didn't reflect on this in advance and set some red lines on where they would go and where they wouldn't. And then I would say seek out others, colleagues of yours, who might join you in those efforts, because fear is the real enemy, and collective action, like those 3 associates took, helps distill and impair the fear and builds pride. And then I would say find a mentor in your firm with strong character and moral and ethical bearings early in your career, and use that person as a sounding board for what you would and would not do. There are a lot of these people in big law, even in the firms that capitulated. There are many, many partners who have strong moral character and strong ethical bearings, and they can be supportive of you, and you can get guidance from them. And then the last thing I would say is, under the oath that you take, that Mac and Highland reminded you of, when you become a lawyer, you have an obligation to do pro bono work, and do it. The need is greater now than ever before, and we need to instill the public's confidence in the profession, and that's probably the best way we can do it. So I urge you, and I don't know a lawyer of over many years of practice who hasn't said that their pro bono work wasn't the most rewarding work that they did in their entire career. That doesn't matter if they won 40 cases in the Supreme Court on behalf of clients who paid them a lot of money, or whatever else they did. It's pro bono work that provides so much satisfaction.
So there are questions in the chat, one of which I'll put to you all, and that is about how law school teaching should be affected by all of what we're discussing today. And this question expresses concern about the absence in online communications of concern about how to teach these issues and maintain respect for the rule of law. What should legal educators be doing differently? Anyone want to take that?
So let me jump in on this. because of the work that we had been doing last spring, starting in March of 2025, to oppose the executive orders, this issue was very top of mind for me when law students who were our 1L and 2L summer associates joined our firm. And I remember talking to all of them saying, are you learning about this in law school? What's it like to be a law student right now in this really strange environment when the rule of law is under attack and this executive branch is doing things that we never contemplated as a possibility? And some of them said, our law professors do not speak about it whatsoever. We feel like we are in a bubble and that we are learning sort of black letter law kind of in a bubble without talking about what's happening in the world. And it's really confusing. And so I do think that it's important for law professors to find a way to talk about it, if only because it's interesting to your students. And I think it feels relevant to them, and they don't know how to fit what they're learning in law school into the framework of like, so what does that mean for what's happening in the world? And I do think that it would be awesome if there were some sort of like template curriculum that could be developed just from a few cases. I mean, these cases that are making their way through the courts are just kind of amazing examples of, at least in the executive order cases, the First Amendment. There's a lot of administrative law involved in many of them. There's a lot of issues where folks could teach, what does this mean? And then the broader picture of how does this fit into the rule of law? I think there's just interest in what that means. I think maybe the upcoming elections could be a chance to kind of talk about the separation of powers and how things are supposed to work. And the last thing I'll say is, and this requires me to be a little bit critical of my legal education, even though I loved my law school, I think I had an amazing education, but I personally found it really hard to understand the rules of professional responsibility that I was taught. I think a lot of law students approach it as like, oh, I got to take the MPRE, like I'm just going to learn whatever I need to learn to just pass it. It just didn't feel real to me. And I think part of it was like I didn't understand just kind of practically what it means to be a lawyer with a client at a firm or an organization that has many different clients. And I think that what's happening with the attacks on law firms and these settlements, it's a great opportunity to teach these basic principles about conflict of interest and the duties to zealously represent your client and, improper restrictions on the practice of law and maintaining the independence of lawyers. I think it makes it more real and understandable. I know it would have been really interesting to me as a law student because I honestly felt like I had no idea what was going on when I was learning professional ethics as a law student.
Another question, are there any lessons to be learned from this pressure campaign against law firms that might be relevant to other institutions currently facing similar pressures today?
I'll jump in that one. So our firm, and along with Highlands and others, represents a lot of academic institutions that are facing very, very similar threats, many of which are perceived as both political and pretextual. And I do think, and this is the thing, again, that I like about what we've seen about these hard times, is all the people helping, the coming together, the alliances between firms that are sometimes commercial enemies, but now coming together on behalf of the rule of law, is we feel empowered. We see that, look, these four firms fought back and they won pretty handily. And at least for a brief time, it seemed like the government wasn't even going to appeal. And so when a very similar playbook, that is a tyrannical seeming government's going to use every possible leverage financially to weaponize whatever power it has in order to bend an institution to its will, you can call that out now and point to examples throughout the country where other courts have found that's what happened. And that's not how you use the rule of law. That's not how you use the Department of Justice. That's not how you use an executive order. And so I know in cases in clients that we represent, they're constantly asking, well, what's happened in this case across the country? We heard someone filed a motion to quash a grand jury subpoena. When I was at the U.S. Attorney's Office, it would be laughable to try to quash a grand jury subpoena because it's so rote, it's so routine. And obviously, we're not doing it to harass someone. We're not doing it for improper purpose. So give us all your stuff, entity. But now these days, those motions are getting a lot better reception from district courts. And I think that's empowering for some institutions. And, they just need counsel that are willing to make those arguments and pick those fights.
So, alas, we're almost out of time. So, I am going to take this opportunity to thank our spectacular panelists and to thank everyone who tuned in for this webinar episode, and also to take this chance to remind you that the next episode in this series will take place next Thursday. It will be hosted, I'm sorry, next Tuesday, March 31st, hosted by Princeton's program in law and public policy. And this panel will examine non-litigation strategies that American lawyers and judges have pursued in response to government pressure on the practice of law. And they have organized just a fabulous panel of experts to speak to these issues. So please do join us again for that episode. And thanks again.
Thank you, Anne.
Thank you.
Thanks for
everyone.
everybody listening in.